So this is the screenshot I took of Tim Ferriter yesterday after his sentencing, and I think, as you can see, he was quite pleased with his sentencing. Anyway, I've just managed to edit through and get rid of a lot of the commentary from the sentencing, and I am now going to play the sentencing for you.
I suspect that whatever I do today will probably make everyone unhappy, because it's going to be a decision that nobody gets what they want, and sometimes that's probably the best approach by the court. And it clearly, he was found by the jury to have been guilty of the 3 charges of which they rendered the verdict on. And so that puts me in a position of finding that the defendant engaged in conduct that the jury found to be criminal for an extended period, and that the conduct he engaged in was considered, it was calculating, it was methodical, and it was planned. I mean, you look at the construction of the room and what that took to put into place, and just the structure, not only of the building of the room itself, but of the method of discipline during the time that RF spent in the state of Florida. The one thing that, and the reason I mention that is because there were plenty of opportunities. This wasn't a one-day deal or a 2-day deal. This was a situation that occurred over a 6-week period in the state of Florida. And so what that tells me is that there were plenty of opportunities that the defendant had to reflect on whether what he was doing was wrong in this matter. So there were opportunities along the way for the defendant to do what I would call a sanity check on whether what he was doing was the correct approach, and maybe a need to reverse course. That never happened. In criminal court, I see it every day. And things like stealing candy, wrestling with your sister and injuring or something like that, those are not serious instances that would ever justify the level of discipline that was imposed here. At the end of the day, the jury found the defendant guilty of the 3 charges that were in the verdict, and so I'm bound by that. But the bottom line is that he was subjected to an abuse that should never be experienced by any kid, from any parent. And I can't just look at the victim's wishes alone in determining what is an appropriate sentence, because no parent can ever be justified in doing what Mr. Ferriter did to his son, RF, in this particular instance. As you can tell, I've considered a lot of things. So this brings me to the ultimate question of what is an appropriate sentence for the defendant on the charges for which he has been found guilty. And so there's no question that the defendant was acting aggressively and irrationally at times during the videos that we saw, and there is no question that there was a methodical, calculated effort to discipline his son in a way that I think he thought was appropriate and believed was appropriate. Although, again, that's weakened by the fact that he did try to conceal that conduct from the neighbors, and so that cuts against that conclusion somewhat. But I do think that the defendant probably came from a disciplined environment, having grown up in Quantico, and maybe that's all he knew. I don't know that that's the case or not, but having been a Marine, I know how Marines operate, and I know how disciplined the environment can be. And I will say that as horrible as the conduct was, the defendant's response in dealing with his son in terms of the room, if you look at the photos, there clearly were times that this family was a better functioning family. They had good times. It wasn't all horrible. It wasn't all the most deplorable of circumstances. So at the end of the day, I'm going to find a basis to downward depart under the catch-all. So the question then is whether I should exercise my discretion in doing it, because I do find that this is a somewhat unique and complex situation because of the situation that maybe the victim has RAD. It's not totally clear that he does. it's not totally clear that what he has wasn't caused specifically by how he was treated by his parents. But I do recognize that there's enough that it creates an issue where this is not your normal situation of child abuse, where their children are put in a cage or a box, and there's nothing that explains what was going on here. Ultimately, the state is requesting 15 years, and I think the defense is requesting 1 year based on the motion, followed by probation. And I do note that I can go all the way up to 40 years. So at the end of the day, as I said before, I am totally convinced that what I do will not please anyone here, but ultimately the buck stops with me, and the responsibility ends with me and falls on my shoulders to issue a sentence that I think is appropriate to the circumstances. I just wish he'd have been a little more forceful in getting the point to me that he actually acknowledges that what he did was wrong, and I didn't get that. I still didn't get that, because I have some sneaking feeling that if all things being equal, the defendant might say that he would do the same thing over again because he thought it was the right thing to do out of love at the time he did it, and that creates problems for me. And at the end of the day, the sentence that I'm going to impose is going to be longer than what the guidelines provide. I'm going to downward depart from 75 months to 60 months, and followed by 5 years of probation, 2 years of the first 2 years of probation of which will be in CC2. During the term of probation, the defendant is not to have any contact initiated with any of the 3 older children. Those children will be free once they reach age of majority to have contact with the defendant if they so choose. In any event, even if the children so choose to have contact with the defendant, they will not be able to do so until the defendant has first completed the following conditions of probation. I'm going to require that the defendant undergo a 40-hour anger management class, which can be taken while he is in custody, that he undergo a 40-hour parenting course, and that he also undergo a mental health evaluation. With respect to the youngest child, given the nature of the appointment or the adoption there, I'm going to require any contact or visitation be supervised, but ultimately subject to any restrictions that the dependency court imposes, because obviously the dependency court, if they're still involved, then maybe they're not involved anymore. They don't have any jurisdiction anymore. So I'm going to leave it that there be no contact unless it's supervised with respect to the younger child. And the reason the court is allowing that is the circumstances that presently exist. All right, so with respect to contact with the minor, the youngest child, I'm going to allow supervised contact as permitted by the adoptive mother, but it must be supervised. So there shall be no unsupervised contact between the youngest child and the defendant where there isn't another adult present. And I'm also going to, it's just as a condition of that, require that the defendant not be in any way, shape, or form engaged in the discipline of the youngest child. That is something now that rests solely with the adoptive mother, and the defendant has no say in that. I want to make sure that that's clear. Thinks it's not enough. That's why I wear the robe and I make the decision. So ultimately, that's my responsibility.
Do let me know your thoughts in the comments, guys. I do read all of them, as you know. I personally think it was too light a sentence. You may think differently, and that's absolutely fine. Do you think it was too harsh? Do you think, like me, it was too light? I will go through all of your comments as I normally do, and I may not be able to respond to them all, but I do my best. So please do pop your comments in, and I will see you guys very soon. Oh, and don't forget to follow me so you don't miss any future videos. Bye for now, guys.